Can you hear me without the mic? You can, no? Yeah? I address chords, so this shouldn't be difficult. Tell me when you can't hear me. So, really wonderful to be back to National Law School. Yes, I like teaching, primarily because nobody answers back to me. Whereas in course, you have a set of people who not only not listen to you, but who are constantly needling you. So the experience is much more worthwhile when you have a set of people who look at you and wonder and think that everything that you're saying is correct. Maybe it isn't. Just before I start the formal session, I notice a lot of young women here. So I'm very pleased. I joined the bar in 1988. And when I joined the bar in 1988, on the criminal side, I was the only woman practicing. When I joined the bar in 1988, I was probably the only woman practicing. And I was viewed as some kind of a strange creature. People couldn't quite figure out why I was there on the criminal side, which is generally perceived as an area of law which is dirty, that nobody wants to kind of put their fingers into. And why in God's name are you going to do criminal law? My association with criminal law was purely accidental, but having said that, I stuck on to criminal law because I found it very fascinating. In 2011, when I was designated by the court as a senior counsel, I was told that I was one of probably the only criminal lawyer to be, woman criminal lawyer to be designated as a senior advocate. So basically, what I want to tell you is that as young students, never forget to dream, because ultimately, it's those dreams that define you in your career as persons. There are glass ceilings waiting to be cracked. You should aim for that. Don't get into the stereotypical mode of wanting fantastic corporate jobs or thinking of options which sound amazing on paper, but which may not be entirely enriching. So my idea also is to convert a lot of you into litigation. That's the underlying vested interest of this trip. But the reason I'm saying this is because there are many opportunities there. There are many occasions where people of your intellectual strength are required in our own country. And you must consider that as an option that you will pursue in future. And don't close your mind to those options just because everybody else from National Law School is joining Amarchand Mangadas and Company, or Dua and Company, or Luthra and Luthra, or become chief law officers of the World Bank. You don't necessarily have to do that. Your options are limitless. And as we progress through this session, I will speak a little bit about it. Now, Professor Nagaratham was very clear that I should start this through a lecture of the law. So I'll confine the first part of my lecture to the law. I call it the journey from investigation to trial. And it would involve provisions and chapters and sections of the CrPC which are of relevance. The second and the third part of the lecture are outside what I was asked to do. The second part of the lecture would be of interest to you. It also is pure legal, and that is we will be analyzing the various judgments on death penalty and the evolution of law in the death, since that seems to be quite a topic of discussion these days after the Yaqub Memon execution. And the last bit, which will be the final bit, will be, I hope, a more interactive session where I will talk about the importance of being a criminal defense lawyer. So let's start with the lesson. That is the journey from investigation to trial. How familiar are you all with the CrPC? What kind of basic structural knowledge do you have? Because it's okay, even if you don't. I didn't know anything in the beginning, that's fine. I'll just run you through. The idea is not to overload you with information and sections, but to just put this into a capsule. What constitutes that journey between investigation and trial? A crime is committed. There are two types of offenses, and you should know that. One called cognizable offenses and the other non-cognizable offenses. And depending on what is the nature of offense, the police will decide to register an FIR under section 154. But you must remember that for an FIR to be registered, the facts of the case must disclose a cognizable offense. Section 155, on the other hand, talks of those cases which are non-cognizable offense. So, now where do you find, how do you determine what is cognizable and not cognizable? If you were to look at your criminal manual, the first schedule of the criminal manual will give you a table which will set out cognizable and non-cognizable offenses. Now, in the case of non-cognizable offenses, obviously an FIR cannot immediately be registered. An investigation can proceed only under section 155(2), where the police officer takes permission from the magistrate to investigate the matter. So, if it is a non-cognizable offense and no permission is taken by the police officer from the magistrate to continue with the investigation, his investigation will be termed as illegal and void. In the case of cognizable offenses, on the other hand, no such permission is required. Suppose an offense of murder under 302 IPC is found to be made out, and FIR is mandatorily registered. So let's take this route. FIR registered under 154. What happens after that? Now, one of the first information report is the first report, the first basic document in a case, on the basis of which investigation will proceed, right? So once the FIR is registered, all the elements of investigation will proceed, which will include recording statements of witnesses under 161 CrPC, collecting evidence, documentary, forensic, or any other kind of evidence which are documentary in nature, which also constitute as evidence and which is integral to the investigation of the case. Recording perhaps statements under 164 CrPC, which is a statement recorded before a magistrate. You now know that with the Criminal Law Amendment Act of 2013, a lot of the sexual offenses which have now been made offenses, including the expanded offenses of rape, etc., in all those cases, it is mandatory that the complainant's statement is recorded by a magistrate under section 164 of the CrPC. After the collection of evidence, that includes recording statements of witnesses and recording statements of witnesses under 164 and collecting documentary, forensic and other forms of evidence, the police forwards what is known as a 173 report, which is loosely called charge sheet, final report, etc., or police report. Now, a 173 report contains the elements of the investigation, includes the FIR, all the statements of witnesses, all the documents. It could end with the police asking the court to summon the accused and to proceed with trial. But it could end with the police closing the investigation, saying that no materials are forthcoming to justify investigation, and therefore we are asking you to close the investigation. That is loosely known as a closure report. I will first take the closure report. There is no, in the Indian legal system, a police officer is entitled to investigate a crime At the end of it, it is the investigating officer's opinion as to whether the crime has been committed by X, Y, or Z, which is of relevance. So if the investigating officer is of the opinion that the persons before him, whom he has investigated, are not responsible for the crime, or that he has not got sufficient evidence to take this further, or that he's looked the whole wide world and hasn't found anybody else who he could say has committed this crime, he generally files what is known as a closure report. When a closure report is filed, the magistrate before whom it is filed has three options. One, the magistrate may accept the closure report, and therefore closure to the case happens. The magistrate may feel that there are elements of the investigation which have not been completed, and there are still clues available which require a further investigation, so the magistrate may order further investigation. And lastly, the magistrate, if he does not exercise any of these options, but finds sufficient material in the closure report to justify the summoning of the accused persons, he may straightaway summon the accused persons, notwithstanding the findings in the closure report. In the Talwar matter, that is what happened. A closure report was filed by the CBI saying that there were gaps in the investigation which could not justify them to further this case, and therefore they asked the court to close the matter. The first informant in that case, before I come to that, when a closure report is filed, under law, the magistrate must first issue a notice to the first informant, informing the first informant, look, the case that you have started on your first information report is now sought to be closed. If you have anything to say about it, you are welcome to join proceedings. So at the time the closure report is being considered, you have not only the investigating agency arguing before the court why the case should be closed, you also have the first informant stroke complainant who is brought there by a notice issued by a court opposing the closure report, saying, more often than not opposing the closure report, saying that the case ought not to be closed. Now, this is not statutorily provided, the notice to the first informant. It has been a law which has developed over a period of time. Starting in 1985, there was a landmark judgment of the Supreme Court, Bhagwan Singh versus Commissioner of Police, and it is in that judgment that the Supreme Court said you cannot close a case without first informing the first informant stroke complainant. And after taking his or her objections on record, only then can the magistrate come to a determinate finding whether to close the case, whether to order further investigation, or whether to straightaway summon the accused persons. So in the Talwar case, they asked for closure. What happened was more devious than that, but in their closure report, they asked for closure. In their arguments in court, they said, we disown our closure report, we want the summoning of the accused persons. Dr. Rajesh Talwar, who was the first informant in the case, asked for further investigation. The court denied closure, denied our plea for further investigation, and said, come and face trial, which is legally possible. Now, how does a magistrate summon a person to face trial? The magistrate exercises powers under section 204 CrPC. Now, let me just repeat this to you so that you get this in its right order. An FIR is registered under 154. Statements of witnesses recorded under 161. Statement of witness before magistrate recorded under 164. Other documentary and forensic evidence collected. At the end of an investigation, the police prepares a charge sheet under 173 of the Code of Criminal Procedure. The 173 report includes a charge sheet asking for prosecution as well as a closure report. In the case of a closure report, the magistrate has three options: allow the closure report, order further investigation, straight away summon an accused person, but only after issuing notice to the first informant. If the magistrate chooses to exercise the third option, which is straight away summon the accused person, the summoning order is under section 204 of the CrPC. Right? Has that been too fast? Do you want to ask any questions at this stage? Or is it clear enough? Can I proceed? My last class was a little more interactive, so you can ask questions. Now I'm assuming that the case has gone to court, that the police has filed a report saying summon and prosecute XYZ. The court has decided to proceed against the accused person. What is the first most important thing first most important judicial function a court does after it receives the 173 report? It takes what is known as cognizance of the offense. This, if you turn to section 190 of the Code of Criminal Procedure, this is perhaps the most important judicial function that a magistrate can take in a criminal trial. Taking cognizance of an offense is applying his or her mind to the facts and circumstances of the case and coming to the conclusion that there are sufficient grounds to proceed. Now, if you were to turn to section 190 of the CrPC, you will see chapter 14, conditions requisite for initiation of proceedings. And we can read that, if somebody can read that for me. Just read 190 subsection 1. Yeah. Yeah.
Subject to the provisions of this chapter, any magistrate of the first class and any magistrate of the second class specially empowered in this behalf under subsection 2 may take cognizance of any offence. A. Upon receiving a complaint of facts which constitute such offence. B. Upon a police report of such facts. C. Upon information received from any person other than a police officer or upon his own knowledge that such offence has been committed.
Let's start. Now the first one is, so there are three areas, three different places where a magistrate can take cognizance. What is your understanding of 191A? Upon a complaint of facts which constitute such offence, because we are talking about 191B. Upon a police report of such facts. A charge sheet under 173 is a police report of such facts. So that's simple enough. If a charge sheet is filed, the magistrate will take cognizance under 191B. What, according to you, is 191A? Because it's a very, very important part of criminal prosecutions. What is it? A private complaint. Absolutely right. A private complaint. So there is a complaint case procedure which runs parallel to the state case procedure, which I will talk of a little later. But enough to say that a magistrate who is taking cognizance takes cognizance on one of these three fact situations: on a private complaint, disclosing the commission of an offence, on a police report, or an information that he may receive, not necessarily from the police, from any member of a public or anyone else, which is a third category, which is not very often used, but which still exists in the statute book. So I'll come to the complaint case procedure a little later. Yeah, you wanted to ask a question? 191C is very different from, see, 191A has a certain formality to it. When you talk of complaint case, there is a way in which complaints are filed, and there are requirements of the law which must be satisfied before cognizance of a complaint case can be taken. In the case, 191C is actually much looser, less formal kind of a situation where a magistrate is told neither by an identifiable complainant nor by the police that a serious crime has taken place and that he should take cognizance of the offense, right? So it's not like you are going to court and making a complaint that X has done this to you. So there is no structure to 191C, whereas 191A and B are structured. There is a definite complainant, there is a definite link between the complainant and the crime, and then it's taken forward. 191C is more loosely worded. It is to take into account all those cases for which perhaps nobody has come ahead to complain, but the magistrate on his own or through someone who might want to not disclose his identity is made cognizant of facts which give rise to the commission of an offense. Yes? Sorry? Can be through media reports as well. Can be through media reports. Absolutely. Absolutely. Are they? CBI? No, no, no. CBI would be 191B. Absolutely, absolutely. What is a CBI? It's an organization which is established under the Delhi Police Establishment Act. It is a wing of the police. It's a specialized wing of the police. So the CBI's investigation and the CBI's prosecution all come within the ambit of police powers that are defined under the CrPC. So the CBI is no separate, it's just another wing of the investigation. You have states which have SITs, you have crime branches, you have, so CBI is another nomenclature given to another investigative wing of the state. Right? Can I move on? Right. So now, cognizance is taken under section 190. What happens after cognizance is taken? After cognizance is taken, so I come back here. I talked of a stage where the magistrate disagrees with the closure report and summons an accused person. Says, I am not agreeing with your finding. There is sufficient evidence in your closure report justifying the summoning of accused persons. That power the magistrate has. Can the magistrate summon under 204 directly, or is there a stage in between? The answer is there is a stage in between. What the magistrate does is first take cognizance of the offense under section 191B and then exercise his powers under section 204. Do you understand now the matrix? So whenever a summoning order is passed, it is a prerequisite that the magistrate ought to have taken cognizance under 190, whichever form. Now I'll stop here. We've reached a certain level as far as the state case procedure is concerned, right? But as you rightly pointed out yourself, under 191A, the magistrate can take cognizance of an offense when he is placed with a complaint disclosing the facts of that offense. That is loosely called as the complaint case procedure. Now, what happens in a complaint case procedure? A private complaint, not everybody wants to go to a police to investigate their matter. Or people have gone to the police, but the police have failed to register an FIR. In that case, the option of proving your case on your own is not foreclosed by the CrPC. What do you do then? You file a complaint. That complaint must disclose the facts and circumstances which constitute an offense for which the magistrate must take cognizance under 190. So in a complaint case procedure, you first have the complaint. Complaint is defined under section 2 of the CrPC. The magistrate takes cognizance under 191A and directly proceeds to the stage of 200 CrPC. What is 200? the statements of the complainant and his witnesses or her witnesses who will help him or her prove the case is recorded under section 200 of the CrPC. So when you file a complaint, your complaint must be annexed with a list of witnesses and a list of documents that you will be seeking to prove through your own procedure. The first thing the magistrate says is, ask your witnesses to come and testify on oath. So statements of the complainant's own statement, and those of his witnesses, if any, are recorded under section 200. Documents which are in his possession are also proved through the testimony of these witnesses. And thereafter, you come to 204, which is the summoning of the accused person. Before that, there is 203. The magistrate, on examining the complaint and examining the testimony of the complainants and its witnesses, may come to the conclusion that no offense is made out and dismiss the complaint. That dismissal is made under 203. But if he chooses to go ahead, the summoning is under 204. So you now come to the same page as with the state case procedure. The summoning is common in both procedures. However, in a complaint case procedure, there is another strategy which is very often followed. I file a private complaint against X and Y, claiming that they have cheated me, forged documents, used those forged documents for the purposes of cheating. But I am conscious of the fact that the documents in my possession will ultimately not be able to unravel the ramifications of the crime, and a police investigation is a must, because I do not have the powers of police investigation as a private person, and therefore the police investigation is a must. I've gone to the police station. The police is refusing to register my FIR, so I file a private complaint. But when I file a private complaint, given the gravity of the offense, given the fact that I make a plea to the magistrate that this is in fact a pretty large scam, the unraveling of which will take some effort, as an individual I cannot do so. I cannot get all these reports examined by forensic people. I have no access to information. Kindly order a police investigation. The magistrate has the power, and that is very, very important, under section 156(3) of the CrPC, to order a police investigation on a complaint received by the magistrate from the complainant on the ground that the gravity of the offense is such and the inability of the complainant to further to unravel the crime is limited. Therefore, a police investigation in the facts and circumstances of the case is an absolute must. This police investigation is ordered at what stage? At the precognizance stage or the postcognizance stage? Precognizance stage. So, once a complaint is filed before a magistrate and the magistrate is told, listen, I don't want to lead my own, don't go straight away to 200. I need a police investigation in this case for these reasons. The magistrate examines my plea and comes to the conclusion that a police investigation is a must. Therefore, the magistrate orders a police investigation but has not taken cognizance of the offense under section 191A. Once a police investigation is ordered, the entire state case procedure comes into play. An FIR will then be registered, statements of witnesses under 161 will then be recorded, and a charge sheet will be filed under 173, at which point the magistrate will take cognizance of the offense under which provision? 1A or 1B? 1B. Because the complaint has now merged with the charge sheet. And then the summoning takes place under section 204. You have a question? Of course. Of course. In fact, what happens in real terms is because, you know, under law now, the first informant is given an opportunity to resist the closure report. And we file what is known as, although it's not defined anywhere in the CrPC, it's a practice which is developed, we file what is known as a protest petition. We are protesting against the closure of the case. So even if the closure report has been accepted, the magistrate may take cognizance under 191A on the protest petition and say, now you prove the case. Right? So they have done whatever they had to do, but either for your satisfaction or because I feel there's some merit in what you're saying. Let me see, I don't want to foreclose this option forever and ever. You now prove the case. So the protest petition then gets converted into a complaint, and then cognizance is taken under 191A, and thereafter the procedure follows. Right? So these are the essential elements of a police investigation, of a private complaint. At your stage, I will not complicate it with more sections and more details because it's not necessary. We are here only to give you a broad structure. Yes? Yeah, very good question. Yes, there is, because it's, what is a non-cognizable offense? When can an FIR be registered? Why don't you all read 155? (155) 1 and 2, if someone can read for me. 155 1 and 155 2.
155 1. When information is given to an officer in charge of a police station after commission within the limits of such station of a non-cognizable offence, he shall enter or cause to enter the substance of the information in a book to be kept by such officer, in such form as the state government may prescribe, and refer the informant to the magistrate. No police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case for trial.
Now stop. So, do you see that once a complaint is made, a private complaint is made to a magistrate, where non-cognizable offences are made out, your question is, can the magistrate still exercise powers under section 156.3? Now see 156.3.
Section 156.3. Any magistrate empowered under section 190 may order such an investigation as allowed.
So, that's your answer. A combined reading of section 155 1 and 2 read with section 156.3 will answer that question. Even in the case of a non-cognizable offence, a magistrate has the power to order the registration of an FIR because 155.2 and 156.3 allows him to do so. It's another thing that practically the magistrate may not do so. Practically, a magistrate may say, this is not a case where I think an FIR should be registered. You prove your case, let the complaint case procedure go on. But that's a separate issue. There is no bar. Your question was whether there's a bar. There is no bar as far as the magistrate is concerned to direct the registration of an FIR on a private complaint, even if the offence is a non-cognizable offence. Right? Now, so this kind of finishes the entire, and this is really a short capsule of the journey through investigation up to cognizance and summoning of an accused. Now you come to what happens in court. Now, charge sheets, typically speaking, under ordinary and general law, are filed before a court of a metropolitan magistrate having jurisdiction. Right? So, even a case which is triable exclusively by a court of sessions, under ordinary and general law, charge sheets are always filed before the court of a metropolitan magistrate. Because cognizance has to be taken by a magistrate. So even in a murder case, which is exclusively triable by a court of sessions, the charge sheet in the first instance will always be filed before a magistrate. It is the magistrate who will take cognizance of the offense under 191B. There are several ministerial functions and slightly more important functions which are thereafter conducted by the magistrate during the time period when the charge sheet remains with him. The first important thing is, so let's assume the cases of murder. Case is of 302. Case is exclusively triable by a court of sessions. Charge sheet must be filed before the magistrate. The magistrate must take cognizance under 191B. Then what does the magistrate do? The magistrate then proceeds to summon the accused under 204. Then you come to the stage of 207, which is a very, very important stage. That is a stage when the accused have appeared before court. After appearance before court, the accused have sought for copies of the charge sheet, all documents, all statements of witnesses, whatever is the length and breadth of the charge sheet. The accused are entitled by right, for the first time since the case has been registered, to all the documents and statements that the prosecution intends to rely upon during the trial. That is the stage of 207, a stage of great importance, because any copy which is deficient, any copy which is relied upon but not supplied, all of which the accused has the statutory right to demand that the same be given to him. The magistrate ensures that the process under 207 is fully taken care of. Once the process under 207 is taken care of and all copies are given to everyone's satisfaction, the case is then committed, committal proceedings. The case is then committed to the court of sessions, which is the court which has the jurisdiction to try the case. Yes? If it is relying upon it, that's an interesting question. You've gone into a totally different space. Now, under 207, and as according to the law developed in our country, the prosecution, unlike other prosecuting agencies in the West, in India, the prosecuting agency decides which statements of witnesses it's going to annex with its charge sheet and which documents it's going to rely upon. And that discretion is given to the prosecuting agency. There is no obligation of what we call fair disclosure in India. That is, you have material which will exonerate the accused, or which will at least raise a doubt about the guilt of the accused, but you are not placing that material before the court, and the court has no access to that material. It is then left to the accused, who may or may not have information about it, to produce it in defense or at some other stage. Now, there are many lawyers over a period of time have developed many strategies to pull that out. But the point is, the law as it stands in India, both the statute as well as the law laid down by the Supreme Court, that law is that the prosecution and the prosecution alone has the singular right, unquestionable right, to place documents, those documents that it proposes to rely upon, and those statements of witnesses that it proposes to bring as witnesses in the case. Sometimes, just sometimes, the prosecution through design or otherwise does produce documents and statements of witnesses that go counter to its case. But as a principle, the prosecution is not obliged to place those documents, unlike, say, in America, where the office of the district attorney, as soon as the discovery is made of any document or any statement or any material which goes a long way towards proving the guilt or innocence of the other side, which the other side must know, they have a legal obligation to disclose it. In fact, we were all members of the latest law committee, the report is not out,
And the paper I worked upon was on fair disclosure, and it is our recommendation that the Indian law must change and fair disclosure must be an element of statutory requirement rather than leaving the onus onto an accused person who may or may not have the ability to access those documents. Yes. Let her ask. 1 minute. Yes. Obligation on the prosecutor. The prosecutor must act as a fair person. But the prosecutor's office and the investigator's office are two different offices in India. They are not interlinked like they are in the West. The DA's office in America has direct control over the prosecution. In India, the prosecutor gets to know about the prosecution only when the charge sheet is filed. He has no way of directing the investigating officer, directing the course of investigation. He has, under the law as it exists today, he comes into picture only when something goes to court. Now, the elimination of certain documents, the elimination of certain witnesses from the charge sheet, that is the sole prerogative of the investigating officer. And if the investigating officer has material, now let me give you an example. I'll come back to my favorite case. In the Arushi Talwar case, when we received the charge sheet, we saw a document, a 100-page document trail from CDFT Hyderabad. This is a specialized laboratory in Hyderabad which is specialized to extract DNA from exhibits and samples that other laboratories don't have the wherewithal to do. So there was this pillow cover of Krishna, who was one of the suspects in this case. Original suspects, the second team of the CBI declared him to be innocent. On that pillow cover, there are many forensic reports which say it's a blood-stained pillow cover. This was recovered from Krishna's room at the time of his arrest, and it is his pillow cover. So that pillow cover, which is famously called the purple color pillow cover. The purple color pillow cover had blood. So the laboratories in Delhi only said blood of human origin detected, DNA not extractable, because they are not very specialized laboratories. So it's sent to CDFD Hyderabad. CDFD Hyderabad, now how this whole process of DNA determination is very interesting, very difficult documents to read. So you take the DNA samples, admitted DNA samples from, in this case, Hemraj, the other deceased servant who had died, from his toothbrush, from his shaving stick, etc., etc. So there are these undisputed DNA samples that you take from there. And you try and match it with exhibits. And what was found ultimately was that this purple color pillow cover, which was blood stained, the blood had the DNA of Hemraj on it. Now, in a charge sheet, which is otherwise based on a fairy tale, this was the only cogent piece of evidence which showed that someone other than the Talwars had committed the crime, because what business did Krishna's pillow cover have carrying the blood and DNA of one of the two deceased persons? Of course, then began the whole process of subversion of justice, where immediately after we brought it to the notice of the court, the investigating officer went to CDFT Hyderabad and said that was a result of a typographical error. In India, of course, life sentences are determined on the basis of typographical errors and no questions are asked. And the matter ended there. But what I'm trying to say is, and I can assure you that the investigating officer, AGL Call, had not read that document. It was 200-page long. He could not have read it. So he must have said, DNA document, it must be nothing. If he had read it, and if he had come to the same conclusions that we had come, and indeed everybody came to later on, he would have pulled that document out. He would not have placed it on record. But because it was placed on record, they went through this elaborate charade of negating the importance of that document. The point I'm making is, and this is something which has disturbed a lot of defense lawyers and a lot of activists, that how is it that the police has the unfettered right to decide in a case? See, ultimately the police represents who? The state. It doesn't represent a party. And surely the state must uphold justice and the principles of justice. So what if the people they're prosecuting aren't really the people who've committed the crime? If there's some evidence which goes in their favor, you must put it before the court. Let the court decide whether they've actually committed it or somebody else has committed it. But in India, the law is that the police is not obliged to place material which goes contrary to their case. Until such time that law doesn't, there is no concept of fair disclosure in this country. It's a recommendation which hopefully the Law Commission will in its final report make. And let's see whether it will be upheld. I suspect that all prosecuting agencies and police agencies will violently oppose that recommendation. Because the minute you place the obligation of fair disclosure on them, half the cases will collapse. Right? So there is no obligation of fair disclosure in our court. Anyway, we've digressed. The police places this information, the magistrate takes cognizance, the magistrate supplies copies, the magistrate then commits the case to the Court of Sessions. After committal to the case of Court of Sessions, the Sessions Court, remember we're dealing with a murder case, the Sessions Court then proceeds with what is known as Sessions Triable Cases. Now before I do that, there's just one section which you people must know, and that comes much before all of this. That is section 167 of the Code of Criminal Procedure. Very important section. I'll briefly explain it. If a person is arrested today, there is an obligation on the police to produce him before the nearest magistrate within the first 24 hours of his arrest. And the obligation also is, how funny, to finish investigation within 24 hours. The British perhaps thought that was possible. It's not possible in independent India. So investigation is never completed within 24 hours. So what does the police then do? The police ask basically for extensions of time. And that is developed through this section, through the process of remand. So, if I am arrested today, God forbid, and I am produced before a magistrate within 24 hours of my arrest, the police will then make an application either seeking police custody remand or judicial custody remand. If they don't want me any further, they can say send her to judicial custody. But if they want to interrogate me, they will ask for police custody. And the magistrate will continue to remand for periods of 15 days at a time, maximum of 15 days at a time. In the case where the offense is punishable with death, imprisonment for life, or up to 10 years, that process of 15-day remand will end on the 90th day. That is, after 90 days, if you don't file your charge sheet, consequences will ensue. So a maximum, if the accused is in custody, the sum and substance of 167 is, if the accused is in custody and the offense is an offense punishable with life, death, or imprisonment up to 10 years, then you must file your charge sheet in 90 days. If the accused is on bail, there is no such time limit. If, however, the case is one which is not punishable by death, life, or imprisonment up to 10 years, then the charge sheet must be filed within 60 days, provided the accused is in custody. Right? Now this 161 regulates the provision for remand. What is important here, and what you must flag for yourself, is the first 15 days are of critical importance. In the first 15 days, the police can ask for police remand. After the first 15 days are over, then it's compulsory judicial custody remand. You cannot give police remand. But in the first 15 days, the police can ask for 2 days remand, 5 days remand. The person can be sent to judicial custody, but you still have 5-6 days of police custody, 5-6 days of the first 15 days remaining. So it's called interchangeable custody. Police as well as judicial. So in the first 15 days, the police gets police custody remand. After the first 15 days, compulsory judicial custody remand, a maximum of 90 days or a maximum of 60 days. This I said because 167 is an important procedure. Now coming back to the matter being committed before a court of sessions, the important provisions is now sessions triable cases, you have to look from 225 onwards. 225 to 233 is sessions triable cases. Now I'll simplify it for you. Basically, the case is committed to the Court of Sessions. The prosecutor will then open the case and commence arguments on charge. The accused has a right to ask for discharge under 225, 226. If a person decides to plead guilty at this stage, then of course he is convicted. If he pleads not guilty to the charge, then you have the process of recording prosecution evidence. Prosecution evidence is recorded. After prosecution evidence is recorded, you have what is known as the statement under section 313 CrPC. When you are recording prosecution evidence, I mean examination in chief, cross-examination and re-examination. All three constitute recording of evidence. You have what is known as a statement under 313, very important section in the Criminal Procedure Code, where each and every circumstance against the accused is placed in a question answer form, and the accused is asked to answer that. So this is the first opportunity the accused gets to put forward his defense. This is not a statement on oath because it cannot be used to incriminate him. But it is an opportunity where the court tells him, it has come in evidence against you that such and such thing happened. It has come in evidence against you that you were at such and such spot at such and such time. And he has an opportunity to refute it or to give his version. After the statement of 313 is over, the accused can, if he so desires, produce defense evidence where he leads the evidence and the prosecuting side gets to cross-examine his witness. And finally, the case is fixed for final arguments where a verdict of conviction or acquittal is given, as the case may be. This is the sessions triable cases. But you have two or three other triable cases under the CrPC, those triable exclusively by the magistrate. And that's a little complex, so I'll simplify it to you. Those triable exclusively by the magistrate are of two types: warrant case procedure, summons case procedure. Warrant case procedure also subdivided into two types: those instituted on a police report, those instituted otherwise than on a police report. Summons case procedure, starting from 251, is the second type of procedure followed by the magistrate. Now all of this depends on the punishment attracted to a particular section. That's how you decide which procedure will be followed. You also have, in some cases, summary case procedure. But otherwise, the structure of the journey from investigation to trial, it is sufficient for you to remember that there are, irrespective of which court is trying the offense, there are stages of cognizance, there are stages of committal, there are stages where the prosecution opens its case and argues on charge, and the accused argues for discharge. If the judge rules that a prima facie case is made out, then you proceed to the stage of taking evidence. The stage of evidence includes the recording of statements of witnesses on oath. It will include the examination in chief. cross-examination, re-examination of, if any, of each and every prosecution witness. When the prosecutor gives a statement that his evidence is closed, you come to the stage of 313 CrPC, which is a stage of singular importance in any criminal trial, where each and every incriminating circumstance is placed, is written down in a question answer form, given to the accused. It normally runs like this. I put it to you that on such and such date, at such and such time, you were present with such and such people. Is it correct? And he has to say it is correct or it is incorrect or whatever else he wants to say. So every circumstance is, but the idea is, it's an essential element of a fair trial that the accused is allowed to give his side of a story. And that's done under section 313 of the Code of Criminal Procedure. Once the stage of 313 is crossed, the last question, in fact, asked of the accused is, will you lead defense evidence? If he wishes to lead defense evidence, that's the next stage. After the completion of defense evidence, you come to final arguments. And when you come to after final arguments, you have a judgment of conviction or acquittal. This, in short, is the journey from investigation to trial. Yeah. The relevance of a 313 statement, as I said, is that, you see, the law in this country is, if you were to read Sharad Birdichand's case back in 1985, 1986, it's a constitution bench judgment. Every circumstance that the prosecution relies against the accused must be put to the accused for his explanation. That explanation is not on oath, but that explanation has great value for purposes of determining whether the plea he has taken through cross-examination consistently adds up to that explanation. So suppose he's taken the plea of alibi. I was never there. I was somewhere else. When they're asking these questions under 313, his response will be, you're asking the wrong person. I was not at the spot. I was somewhere else on that day. So you get a chance, an opportunity to refute the prosecution's case step by step, evidence by evidence. And that is thereafter looked into at the time when evidence is finally marshaled. The first opportunity an accused gets to give his side of the story. So I just, no. If, now they're here again. If it is not obligatory that a judge must record a 313 statement, there are many cases when on a plain examination of the prosecution case, the judge comes to a conclusion, what question do I put to the accused? There's nothing incriminating. So he bypasses the 313 stage and directly acquits the accused. That happens. So 313 assumes importance where there is some material, where there is lots of material, or where there is disputed material. But it gives, if you as an accused feel there is no, that these witnesses, like for example, there are standard questions, PWs 1, 3, 4, 7 have all testified against you. So you can turn around and say, actually they haven't testified against me, they've actually furthered my defense. You know, so you get an opportunity to refute it. You don't have to necessarily give long-winded explanations, but you get an opportunity to refute assumptions made by the court while asking those questions. You get an opportunity to refute the evidence put by the prosecution. They are relied on for, no, see, they cannot be relied on for purposes of adding a charge of perjury against the accused, right? So he can say everything, anything he wants to, lies, everything he wants to, he can say in that, right? Everything is incorrect, everything is a lie. So it cannot be, the law is you can't use the 313 statement for purposes of convicting him, even if he gives a strange answer. But you can use the 313 statement and the explanations that he's giving for purposes of finding assurance to acquit him. So 313 answers will not be used against him, but can be used in his favor. That's the law. I did pick up, or say in a rape case. In a rape case, you are saying that, in fact, I did enter into an agreement with the prosecutrix and there was sexual intercourse. But she was a consenting party. Now, to the point where he admits the incident, that will be used against him. Now, whether he is a consenting party or not a consenting party is a separate issue. So there are admissions which sometimes the accused makes in his 313 statements, which can be used against him. Or, I mean, if there are downright admissions, it can be used. Although, even there, traditional law is try not to use 313 admissions for purposes of convicting an accused. Use his explanations to acquit him, but don't use his foolish admissions to convict him. Yeah. 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 So let's do. It is obligatory only if there is evidence. It's not obligatory if there is no evidence. Now let's read 313 statement. Trial for purposes of enabling the accused personally to explain any circumstances appearing in the evidence against him, the court may, at any stage without previously warning the accused, put such questions to him as court considers necessary. These are called court questions, right? B, shall after the witness, now the difference between A and B is, A can happen at any stage, may at any stage, without previously warning the accused, put such questions to him as a court considers necessary. Whereas B is shall after the witnesses for the prosecution have been examined and before he is called for his. So B is state specific. B is state specific. Prosecution evidence over, defense evidence yet to start, in between you have 313. That's mandatory. A is you have what is called court questions. Now that can happen at any stage of a trial. At any stage of a trial. So there is a whole, for example, in the 2G trial, which is going on now. So there's this whole thing about a witness saying that, you know, some of these industrial houses who are accused was seen in the house of A. Raja for several functions, right? The court did ask the individual accused at that time, did you go to the house of A. Raja on such and such date? They said, no, we did not. But that is what is meant by clause A, where it is not state specific. It is not state specific, it can be used at any stage. It's not used very often, it's used with caution, it's used with discretion, because ultimately you don't want to cut a defense. You don't want to impinge on a fair trial. Right? So, by and large, most courts use it at the end, when the prosecution evidence is over, and that's what B is all about. Right? Anything else? Can we end this session? Huh? So, this is, if you have questions, you're most welcome to ask. No? Okay. So, this really is a very short capsule. I mean, there are many, many more provisions, but I don't want to burden you with it, of the journey from investigation to the end of trial, right? So this kind of takes care of that. My next session will be on the death penalty. Yeah? Okay, there were some questions you wanted to ask from the last session. Yeah.
If I will accuse it, do I have no opportunity to have a look at the charge sheet before it is actually convicted by
before a cognizance is taken? Not under law. You don't have any opportunity to The journey from investigation to the filing of charge sheet is the exclusive journey of the investigating agency. The accused, other than the fact that he can be arrested and thrown into jail, has no role to play in that journey at all.
That's all right, but if the process report is filed,
Yes.
and the magistrate holds that it should in fact go to trial, then do I have no grounds to appeal that process?
Of course. That's a separate. You have all the reasons to appeal against the summoning of you as an accused person. That of course you can do. But you are asking whether you will have access to these reports before it is placed in court. No, you don't have access. You can have unofficial access. In this country, everything is available at a price, but you will not formally, legally have access to those documents or the closure report till such time that it is filed in court and you are summoned as an accused. Statutorily, the only time you get access is the stage of 207, not before that. Yeah? Yes? Who wanted to ask? Yeah. Yes, now this is a question which I answered before, but I think she had difficulty answering, understanding it. In a non-cognizable offense, the question again is, can a magistrate direct investigation with respect to a non-cognizable offense? Even when the person making the complaint has adopted the private complaint procedure. The answer is yes, and what I read out was section 155(2) and section 156(3). When you read these two together, section 155(2) says that a non-cognizable offense cannot be investigated without the permission of the magistrate. So a magisterial consent is absolutely necessary, which is what the magistrate will give. Section 156(3) says that the magistrate can order the registration of a case under 156(3) for all cases in which he is empowered to take cognizance. So there is no distinction between cognizable and non-cognizable at that stage. Therefore, even in a case of a non-cognizable offense, the only rider in the case of a non-cognizable offense is permission from a magistrate. Once that's obtained, it can be investigated. Right? Anything else? Or can we close this?